Today I'm joined by Amy FitzGerald, Executive Director of the BC Society of Transition Houses, Alina McKay, Research Manager with the Housing Research Collaborative at Peter A. Allard School of Law, and Kamaljit Lehal, Barrister and Solicitor at Lehal Law Corporation. We are each going to provide a few comments on RISE's report, and then I will ask all the panelists a question and turn it over to the audience for questions at the end. We'll be finishing around 1:30, and then we'll have lunch and connect. And for the lawyers attending this panel, it is eligible for 1 hour CPD credit with the Law Society. Hearing about the experiences of survivors of violence navigating BC's housing crisis can be difficult, so please take care. Beginning in March 2024, RISE began this research project with generous funding from the Houssain Foundation to better understand what survivors of violence in BC are experiencing in the face of the housing crisis. I interviewed 89 people for this project, 48 survivors of family violence navigating the family law system and the housing crisis, as well as 41 key informant experts with specialized knowledge in these topics. This included lawyers, frontline workers, social workers, transition house staff, and academics. Broadly, what we wanted to find out is what impact, if any, does BC's family law system have on survivors of violence facing housing challenges? Our research found that the ongoing housing crisis across the province and the family law system are putting survivors in dangerous situations, sometimes preventing them from leaving, causing them to return once they have left, and often trapping them in poverty and housing insecurity. Our research centers the voices of survivors who shared their experiences with us. As with all of our research, we heard over and over again about the disconnect between what survivors experience and the risks they face, and being met with a legal system that doesn't understand family violence and responds in ways that can make things worse. But the problems with the family law system are simply a mirror into the same problems that are so pervasive in our society. Myths and stereotypes about gender and violence are pervasive, and they work to undermine the seriousness of family violence and to discredit women and gender diverse survivors when they come forward. Society says if it's really so bad, she should just leave. But the reality is survivors who leave are so unsafe that they are asking, should I have just stayed? People working within the family law system are not responsible for solving the housing crisis, but they do need to understand the direct link between family law remedies, housing, and family violence. 45% of women over 15 in BC have experienced intimate partner violence, and the most likely place where violence takes place against women and girls is the family home. Violence is the leading cause of homelessness and precarity for women and girls. 75% of women leaving a transition house in BC remain temporarily sheltered or return to their abuser. BC has the highest rental prices as well as the highest rates of eviction across the country. There is a lack of safe and affordable housing that makes it incredibly difficult to leave. In the report, we detail how family law remedies fall within two broad categories that are directly tied to whether or not someone is going to be able to avoid homelessness after they have left. Starting with the ability to pay expenses. If someone is receiving child support, spousal support, gets their division of property, this increases the likelihood they are going to be able to find safer housing. Financial insecurity is the greatest predictor of whether or not someone will return to a violent relationship. Physical safety and housing. We aren't asking the family law system to put a roof over people's heads, but in some cases, it is already doing that. Survivors are often the ones fleeing with their clothes on their backs, and they are the ones left to apply for protection orders, for exclusive occupancy of the family home, to apply for the division of family property, to apply to relocate with their children. They are asked to facilitate parenting time with their abusers, and in some cases, they are even being required to supervise it. With the onus on survivors to make this work while they are at an increased risk of violence because of the separation, we need a family law system that's designed to recognize that these remedies can be the difference between someone staying or leaving. British Columbia's housing crisis creates unique challenges for survivors of family violence who are seeking safety and stability, and in many ways it intensifies the dangers that they face. In our report, we detail the connection between the ways abusers perpetrate violence, including through coercive control, and the housing crisis. One way in which coercive control manifests is by threatening housing precarity or taking steps to obstruct housing options for survivors. Economic abuse and social isolation are also perpetrated as tactics of coercive control, and it's easy to see how this affects somebody's ability to leave. Where do you run when you have no money and nobody to call? Survivors stay longer in abusive relationships when they cannot find safe housing for themselves and their pets. Our report details horrific incidents of direct violence towards pets, which we know is extremely common given the correlation between intimate partner violence, child abuse, and pet abuse. We go through the challenges to the family law remedies within the report, and we worked really hard to take our findings and offer solutions. The way we wrote this report was to think of the people that we interviewed, the survivors, as well as the clients that we work with, and ask what would they need to make the family law system work better for them? What would that look like on the ground? I want to give you one example of the many recommendations we make within the report. So let's imagine a woman leaves with her children, she goes to a transition house or stays with her friend, and the next day she receives the child support that she's entitled to. It's paid immediately by a government agency. It is then the government agency's work to get reimbursed by the payer. This is how it works in Norway. Then there is a predictable amount of money, it is immediately paid, and what it does is it gives more choices to this person as to what their next steps are. So where do we go from here? RISE has launched, as of today, a CPD accredited platform for training for lawyers called RISE Professional Legal Education, where we will now have a website with training for lawyers, and as of today, the first part of our course on housing is available, Housing and Coercive Control. The 4 arrows on the screen are all trainings that will be developed for lawyers from this report. Despite the challenging system we find ourselves in today, I have so much hope, and I'm inspired by all that is happening in BC right now, including the work of the community organizations who are working in housing, in anti-violence, and in social justice, as well as the direct work being done by the provincial government, including on modernizing the Family Law Act and taking an evidence-based approach to improving access to justice in BC. Lastly, this research project itself makes me so hopeful. Survivors often told me that why they wanted to participate in this project is because if only people understood what they went through, if people really knew what it was like, things could change. They generously shared their experiences in the hopes that others could better understand. So, thank you so much for being here today, and I'll turn it over to Amy.
Hello everyone, it's my honor and privilege to be here today. I'm the Executive Director of the BC Society of Transition Houses, and really it was my honor and privilege to collaborate with RISE on this report. Family court is woven into the work that our frontline folks do on a daily basis. It's one of the highest support requests that folks ask for when they come into the transition house setting, and we need to do it collaboratively, and this gives us a pathway to do it better together with the government. So who we are not frontline. We have the privilege and honor of supporting the 141 members across the province that are doing this frontline work. So those are the safe homes in rural and remote locations, the transition houses in more urban and metropolitan settings, the second stage housing and third stage housing, and now long-term housing that our members are providing. They also provide important psychoeducational counseling to children and youth between the ages of 3 and 18 with the PEACE program. And they also go into schools and deliver prevention and awareness programming called Violence is Preventable. All these folks are 24/7, answering phones and making sure that women, children, and youth at risk of violence and fleeing violence are safe on a daily basis. All right, so this gives you a sense of the breadth of our folks in community. We are across the province. Currently, 30% of our members are in rural and remote communities, which face even greater challenges. The rates of intimate partner violence are 4 times higher in rural communities. 23 members are Indigenous members as our society. And also the folks who are walking through the door right now, 53% are women and self-identified women, and 47% are children and youth. And that means that the majority of them are addressing family court on their daily basis. So this is the housing continuum that exists in British Columbia. So you'll see this continuum. And this was designed at a time, to be honest, when we had social housing and market housing at the end, where we had these temporary spaces along the way that provided wraparound support services by all the folks that are my members. And then they would reach that long-term housing. And what happened because of the affordable housing crisis in British Columbia is there was a bottleneck at that long-term housing. And as a result, women who were brave enough to take the step, to go into shelter, to leave their abuser, were getting stuck in these transitional spaces and places. And they're not designed for long-term housing. They're designed for transitional support services. And so that's the problem that still exists in British Columbia today. There has been an investment by the province with the Women's Transition Housing Fund to build an additional 3,000 units of housing. So that will increase this continuum from 800 units that we had in 2018 to a total of 3,800 units when all those units are built. About 800 of those units are built. And of those, 8 of them are long-term housing, but that's a drop in the bucket. So we're still stuck in this affordable housing crisis, and it plays out in the family court matters that folks are dealing with on a daily basis. To address some of these issues, BCSTH started doing housing research in 2018, and these are some of the findings from the reports. None of these will be a surprise to any of you. Affordability, accessibility, discrimination, and poverty are barriers to women when they're fleeing violence and looking for housing. And then we also, in our Keys to Home project, identified that the actual housing stock that's available to them is not appropriate. So these are all the elements that we were attempting to address. With the investment with the province, the good news is that we had an opportunity to work with our members to design women-centered housing and operations. And that's the model here. And there's a women-centered design toolkit and on our website, and there's also a toolkit about how you develop women-centered housing. The important part about this housing is that we're designing is, the design is that there's the inner circle. It's designed to provide security, a sense of safety, convenience and efficiency, home-like and healing environment, physical comfort, and community support and social life. And this was designed in concert with frontline providers and also women with lived experience. And those 5 elements are really what we're trying to get the family court to recognize in the work that they're doing. And they have the ability to do it based on the pathway provided in the RISE report and also provided in Kim Stanton's recommendations. So this is where we are here. Family law does have a role. Family courts do have a role. And the idea behind this is to shift from the danger and housing precarity and financial abuse that 48% of women in British Columbia face to safety, housing security, and financial independence. And as it states in the RISE report, family court remedies should be urgent, predictable, and violence-informed to shift this dynamic. And so I am hopeful with this report, and I'm going to touch on a couple of the recommendations in the report that I think will make a difference. And the family court does have a role to play. And the reason why the family court has a role to play is that it was designed to place the safety and best interests of children first and included provisions for protecting individuals at risk of family violence. And that's when it was adopted in 2013. So given this mandate, how can the family court truly foster that safety and housing security and financial independence that the RISE report talks about for survivors and their families fleeing violence? A 2019 Department of Justice study indicated that family court lawyers stated that 51% of their cases have family violence in those matters. So if that is the reality of the folks that are walking in the door of family court, then family court has an obligation under the Family Law Act to ensure that their remedies are urgent, predictable, and violence informed. So in terms of shifting from the hopelessness that many of us acknowledge because of the work that we do with survivors and our frontline members every day to hopefulness, some of the recommendations in the RISE report I just want to flag to you. One of them is to impose accountability measures for non-disclosure and non-compliance, to guarantee child support, as Haley stated, to allow survivors who are entitled to family property to have access for interest-free secured loans from the government after separation, which is an investment in a safe future. In terms of safety, we need to look at the protection orders. They are on a short-term basis oftentimes, they increase the danger, and survivors rarely apply for the exclusive occupancy remedy. Instead, they flee. And why is that? There's a provision in the family law that allows for that, so why is that? They come to transition houses, which often don't have capacity. We have to look at unsafe parenting orders, and also relocation is a huge barrier to women fleeing violence. Finally, the RISE report recommendations are woven throughout the RISE report are also Dr. Sam's recommendations, which reflect that. The definition of family violence should include more types of family violence, including the risk of family violence, and we should extend the duration of the protection order. And she talks about funding for supports for survivors in the legal system, and also ensuring that children are really, the safety of children are really at the heart of the work that we do. So we're very grateful to be part of this collaboration. We're very grateful to be part of this pathway forward to ensure that women with experience of violence in family have a future of safety that includes housing, security, and financial independence. So bravo to RISE, and thank you for all your work.
Good afternoon, everyone. I don't have a PowerPoint, so you'll just be looking at me. I've been asked to come in and provide a different lens to the report that was prepared. I'm primarily an immigration lawyer, never practiced family law. I do family law mediations, and it's an interesting area now where we're also actually negotiating and resolving family violence in those mediations, done very strategically and keeping people safe. But, so I'm here to bring the immigration lens. There is snippets throughout the report, the RISE report, where there are individuals who are immigrants that have shared some light on what they go through and how they navigate the processes. And it is a process for women to navigate. And unfortunately, the way the systems are set up, they still are in silos. So you have a woman navigating the family law system, you have her navigating the criminal law system, and then dealing with various resources she needs access to. So it's daunting to say the least. And if we change that woman and make that woman a racialized woman, a woman with intersecting identities, the barriers that she faces are even heightened. If you make that woman an immigrant woman who has precarious status, meaning maybe temporary status in the country, or is out of status, it's even further heightened. You have threats, and this has been going on. I've been doing this work for decades now, from the perpetrator saying, but I can have you removed, I can have you deported. So it's not just a matter for these individuals trying to leave the relationship and find a home, but to be able to stay in Canada, especially if they have children. So it's quite a daunting process. And again, the report I think, speaking for myself, it shares knowledge we've shared many times, over and over again, but I love the fact that you've got some very concrete recommendations, maybe that you've touched upon, and hopefully they'll be taken seriously and we'll get those implemented, or parts of them, or we gotta just keep pushing. So when I'm looking at things from the immigrant woman's perspective, and a lot of my work is representing women who are either out of status, they've come to Canada, they're in a relationship, it turns abusive, and they may or may not have children, but they need to remain in the country. So it's trying to get them status. If they're out of status, it's trying to get them status, temporary status. It's called a temporary resident permit. And then if they want to remain permanently, it's another application called typically a humanitarian application. So, and it used to be that if they were out of status and I was navigating these processes, then we had the enforcement arm of immigration working, which is the CBSA, who are mandated by law to remove. That's a mandate as soon as possible, anyone that is without status or has a removal order issued against them. So these are the hurdles that these women are dealing with, and many of them, and we did research, I think it was 2009, it was UBC and a number of organizations did focus groups, that there were even instances where CBSA was going into transition homes to find out of status women and have them removed. Since then, things have changed. We now have, as of 2019, an expedited process for these victims where they can get status. Their files are coded FB for family violence, and they get expedited status, and they get expedited permanent resident status, and removals is put on hold. It's all in policies, not regulation, though that's the only downside of it, but it's been working well so far, and I'll tell you why I mean by so far in a minute, but it always helps for you to understand what my clients are going through, what women with these additional intersecting identities go through, for me to provide an example. I had a young lady a few years ago, 3 children, who married a man in Canada, and she presented with a common theme that I've seen over and over again, one of isolation. And by isolation, I don't mean she's in a remote area. Certainly that compounds things, that type of isolation. But isolated in the sense that the family has cut her off from her family abroad, from her home family, is limiting her access to the outside world. She's also isolated by virtue of limited language, English abilities, and knowing the culture and knowing her rights. So a number of other compounding factors. The only way this particular client of mine just happened to get out and get the help she needed and get to transition housing and ultimately housing was she was expected to work in the farms, so she was in the farms with her mother-in-law and with her kids, and there was a fight between her mother-in-law and her, where the mother-in-law threatened her, so she went off crying. Someone saw her, a good Samaritan, took her into their home, called for help for the transition home, and she was able to get out, didn't go back. We navigated the immigration processes. She is here on PR status, and if it was not for the great work of the transition home and allowing her to stay longer than is required, she would have ended up going back. And there were threats of removing her from the country. So what I'm trying to impress is when we add all the different identities that women come with, it's a real challenge to get out of that door to safety and to a safe door. I applaud the work that's being done here. And I don't want to leave things on a damper, but the reality I want to also share is in the immigration world, and you probably see this in the news, it's the sky is falling. We're seeing a real significant change in rights and liberties for immigrants, from refugees to humanitarian classes. We're seeing announcements that levels across all categories are going to take place, which will impact humanitarian applications. I'm not exactly sure what's going to happen with the expedited process at this point. So it's, I'm a bit of, I've got a cloud over me, I think, most of you everywhere right now. But I'm still hopeful. I'm hopeful with, I get energy from, when we come together like this, and we're all doing great work. Again, I applaud RISE for the work that they're doing, and also inviting me here today to provide that immigrant women's lens.
doing today? So I'm Alina McKay, and I'm the housing research manager for Housing Research Collaborative and Balanced Supply of Housing. And I'm going to be zooming out a little bit today, thinking about those structures that actually make the housing system really difficult to navigate for women, with a specific example of national occupancy standards. And this comes out of some work that BC Society of Transition Houses started in 2019. Amy mentioned putting together that housing research team within BC Society of Transition Housing, led by Candace Knowles, that really started talking to transition houses and asking them, why are families getting stuck? What's happening? Why do so many women return to the homes that they fled? So I'll talk about the policy problem that is national occupancy standards, as well as the NAHA report that we put together on this. So what are national occupancy standards? They are standards around what housing is considered appropriate for a household to live within. So they say, I think we should start by just naming it that they're very colonial, and they really focus on that nuclear family. So the focus is around, two adults living in a common law relationship. These can't be, say, like mother and her mother, are able to share a room under national occupancy standards to be appropriately housed. Two children of the same gender under the age of 18. National occupancy standards, it does still use the language of sex as well, I will add, so very problematic there. And then also two children of different genders under the age of 5 are able to share a room. So this really restricts families and also households, just because it's very based on this nuclear family idea where you have two parents are in a bedroom, and then each child maybe has their own bedroom, which is that ideal, but within our housing system doesn't work for lots of reasons. Where did this come from, right? There was, in the 1990s, we really saw the federal government download responsibility for housing to the provinces. And one of the things that happened when that happened was the federal government said, we're gonna look at core housing need within each of the provinces. And they went to all the provinces, and they had a big consultation in the 1980s when they were thinking about, wanting to lower the deficit for the country, and they wanted to create download this responsibility to the provinces. So they said, okay, what's important to provinces to look at housing need? Housing has to be adequate, right? It has to be in good repair. It can't the roof can't be falling in. Plumbing needs to be working, things like that. Has to be affordable. So they define that as 30% of the household income before tax. Problematic, but there you have it. And then also suitable. So suitable housing, again, drawing on these national occupancy standards, which were through these consultations. And so we see in 1991, the first housing needs assessment for Canada is produced by Stats Canada. Stats Canada starts collecting this data on households and saying, are households in Canada adequately housed, affordably housed, and suitably housed? And then there's also another piece of it can they afford to move to housing that meets these three needs? So that's like an income cutoff, right? So it also considers, say that a household is inadequately housed or unsuitably housed, but their household income is quite high, so they could, rent a house that met those needs. They wouldn't be considered in core housing needs. So it helps the federal government then decide, okay, we have 200,000 households in Ontario, for example, that are in core housing need. Maybe that should direct money to the province and help them address those households and meet their housing need, recognizing that the government has a role to play in actually creating affordable housing. What we see is that those government transfers actually do not really respond to housing need in any of the provinces. And so instead, we see that many social affordable housing providers in the 1990s actually adopt national occupancy standards to allocate social affordable housing. So rather than it being something that the provinces can say, look, we have all these households that are in unsuitable housing and they can't afford to move to housing that meets their needs. We need to, as a province, we need to build another 150,000 units of 2-bedroom and 3-bedroom housing. It becomes a barrier for households looking for that housing. So under national occupancy standards, for example, you have a family with 2 children, and the family on the right here is going to need a 2-bedroom home, right? They have 2 children of the same gender. Those 2 children under national occupancy standards can be in the same room up to the age of 18. So when we're allocating social affordable housing in a province like British Columbia that has adopted national occupancy standards, that family can move into a 2-bedroom. And there's enough, say 2 bedrooms, there isn't, but 2 bedrooms that family can move into that housing. Where we see single mother with 2 children of different genders, under national occupancy standards, this family on the left would need a 3-bedroom unit according to national occupancy standards because the children are over the age of 5, different genders. And so, the social affordable housing providers start to tell transition housing, and specifically this is impacting families, oh, you need a 3-bedroom. We don't have any 3 bedrooms. The wait list is actually, 5 or 10 years for this. So we see this really trickling down and creating big backlogs. So this is the policy problem, right? This tool that's meant to sort of measure housing need and help the federal government identify how much money should be transferred to the provinces to help them meet these families in need actually becomes a barrier to families in housing need. So it's one of these really tricky problems where something that was never meant to be used to actually allocate social affordable housing becomes a tool used to allocate social affordable housing. And so this is just a quote from our research, just pointing to the fact that these standards, right, become a barrier to safety, become a barrier to families being able to seek out safe and secure housing. And so many of the issues that Haley's report points to, right, where there's this, the sort of piece that's missing, there's lots of pieces, but when families are in the family court system, right, and the sort of very basic need is an affordable place to live, an affordable place, a safe, affordable place, and they might have an extension out of transition housing, but when it comes to actually securing long-term housing, it's just not happening. They're being turned away. They're being told that their family doesn't meet the needs, that there's no housing that will ever meet their needs. In some cases, we had families that we talked to that just said, so that the social housing provider said, I can put you on a wait list, but we will never have housing that actually meets your needs. So we put together a report that was submitted to the NAHA panel for the National Housing Council, and the actual NAHA recommendations were released today, so very exciting day for the sector. And then just highlighting what I've talked about today, just that national occupancy standards were a barrier to housing for many households that we talked to. And then we also talked to some service providers as well. And then also that they're right, the impact is especially great for Indigenous households, racialized women, non-English speakers, single mothers, and folks with disabilities, as well as larger families. And then he was going to ask me about the recommendations.